here understand Russian well enough, I think. But still, thank you very much for coming. We are very glad to greet you here at our office. And for those who joined us through the web translation, thank you for joining. And we will be, of course, willing to greet all of you here at office, but we understand that in the current circumstances, it is very difficult for many people to join and to come in person. We want to say special thanks for Japanese Business Club. With support of this organization, we organized this event, and special thanks to Okada-san, to the people of Japanese Business Club. So today our topic will be devoted to personal data, and our speakers will be two leading lawyers of CMS in this field, Irina Shurmina, our senior associate, and Vladislav, Eltovskiy, our associate, who are leading specialists in this area at CMS. We recently have more and more inquiries from various clients regarding personal data, and especially many inquiries from Japanese clients. So I think this topic can be interesting, and of course we are not limiting today ourselves to the presentations only, but we are open to discussion. That's why we choose this format. It can be very convenient for discussion, for answering questions, and so on and so forth. And for people who are listening us through the web translation, they can always open the chat box and ask their questions in the chat. So we will be monitoring the chat as well, and we'll ask questions to the speakers after the presentation, I guess. But anyway, you can interrupt us always and ask questions, I think, in the middle of the discussion. So please, guys, I will not waste your time. I think Irina will start.
Yes.
So,
thank you. Good morning, dear colleagues. We are really pleased to have this format when we can look at your eyes, because all this 2 years almost we were talking to you through the screen and we did not see your reaction, and we're very pleased to have you here. All those who are online, hopefully we'll meet soon, but still it's very good that you were able to join. So yes, as Georgy mentioned, for those who are online, there is a special section, questions and answers box in your broadcasting software, so you can use it for your questions. Our tradition with Vladislav is that we answer all questions, so please do not hesitate. Of course, if they are not, if they are too substantial, we will take our time and revert to you later. But we do not, miss some questions, not to answer something. We are pretty kind of confident. I hope that it will be like that during this event today. So our agenda today is, first we will talk about what is actually considered personal data in Russia. Second, we'll talk about grounds for processing, and we have some developments there. So we need to give you updated information. The most hot topic over the last year is dissemination of personal data. There are new rules for making data available in public sources and using data from publicly available sources, which is maybe even more tricky in this sense. Also, we'll talk about consents for advertising and marketing. We know that every company has its marketing strategies, and it's important to do it right, not to have more problems with it than the benefits. And of course, we'll talk about localization requirements and cross-border transfer. These are topics that are hot for many years already, but still new and new requirements and new liability is there, so we need to pay attention. So let's start with the first topic, what is considered personal data in Russia. According to the law, it's any information related to a person who is identified or could be identified, so the definition is quite broad. And of course, we are used to the standards that name, passport details and contact details are considered as personal data. Several years ago, people were still hesitant whether email address is actually the personal data, but I think now it's more or less clear that it is, especially if we are talking about corporate addresses, which identifies not only the person but also the place of work. So yes, also the phone number is still in this, I wouldn't say gray zone, it's almost already in the clear zone, let's say, but yes, in most cases, phone number will be considered personal data, but if it's just a phone number, maybe it can be not personal data because you are not a mobile operator to actually identify this person. But if it's in the set of data, so you have something else, then most probably it will be personal data. But this is like a traditional set of data. We have more innovative and technical set of data like MAC address of your phone, for example, or it can be IP address of your notebook or something like that. Then it can be your location and history of purchases, for example. What you like, what your preferences are, where you go to the shop, which shop it is, what time you go to the shop. So it's various history of your preferences. And this kind of data is already as well considered personal data by Russian courts. Unfortunately, we do not have much case law in this regard. And this is the problem that we are facing all the time as practicing lawyers, that unfortunately we see that there are many problems, but there are not so many answers. But still, we have 1 or 2 decisions about this MAC addresses and IP address and locations, and we are sure that these technical identifiers are considered as personal data. As regards history of purchases, there is no, as far as we know, there is no such case law. But in the market, it is considered also as personal data if it's matched with any other identifier. So basically, anything that can somehow identify a particular person or identify a person within the crowd. You know, we may not know that this is Irina Shurmina, but we know that this is identifiable person. And if we look in other sets of data, we will understand that this is the same person that we are kind of monitoring. So the definition is quite broad, and this is what should be remembered all the time when we deal with personal data, that basically any data can be considered personal at any time. There are also special categories of personal data. This is in the law, and this is data about race and ethnic origin, religious and philosophical beliefs and political opinions. Of course, it's health data, and we know how much important this data has become over the last years, when before we could say that our organization does not deal with health data at all because we are not a medical organization or something like that. Now everyone deals with health data, so this is a very important category. Also information about intimate life and biometric data. Of course, if you have face recognition, for example, in your company, then you process biometric data. Yesterday, there is a kind of community for Russian privacy professionals. There is an association, and yesterday I was looking in the Telegram chat that we have with this community, and they were discussing whether the marital status, whether you are married or not, is actually data about your intimate life. And people were like, well, no, or maybe yes. I mean, this is, of course, your intimate life, kind of. But is it the information about your orientation, for example, or not? Because in Russia, it's only, allowed to be married to a person of another sex. Then that means that possibly it's a kind of information about your orientation, or it's not. So, there are discussions about even these categories of data which are in the law for many, many years, and there is practice, but still we're facing more and more questions in this regard. I will not answer about the marital status because I think there is no proper answer, but of course, to be on the safe side, yes, we will consider this special category, although, many companies may not agree because everyone collects this data in its traditional. So yeah, this is to show you how broad the topic is and how many questions are still there. But now we'll move on to rounds of processing, how to actually deal with this, any data that can be out there, and what grounds to choose. Vladislav will talk about.
Hi everyone, once again, thank you for coming. My name is Eltovskiy, and I will quickly continue with our presentation. So one of the main obligations under the Russian data protection law is to justify processing by certain legal ground. And on the screen right now, you can see, like, I would say most widespread legal grounds. First, 3 of them will be discussed in detail later, so I will not focus on them right now. Maybe I will say couple of words regarding performance of statutory obligation, which is quite widespread justification as well. However, we always warn our clients that when you refer to this legal ground, you should be sure that without processing of personal data, exactly this statutory obligation cannot be performed. So, not to not waste time, let's start with the most widespread, I would say, legal ground for data processing. This is consent. Consents could be of several types, and we will speak about this, but the general requirement for consent that it should be informed, conscious, specific, and freely given. What does it basically mean? That you shouldn't hide consents inside like long forms of agreements where it could be disputable whether the data subject has been really acknowledged with the consent and has made an explicit consent to certain personal data processing. As regards such criteria as consent to be informed, we always recommend to include in the wording of consent what personal data should be processed, for what purpose, by what means, so that on the basis of reasonable expectation, you can be sure that when data subject signs a consent, he or she understands what exactly will be processed, how, and for what purpose. So that there should be no like second opinion about this. It should be also noted that in Russia we don't have like balance of interest tests in terms of whether consent is freely given or not. For instance, under in Europe, when you ask for consent from an employee, this seems to be unbalanced because employee is always dependent on the employer, and therefore the consent cannot be considered as freely given. However, in Russia right now we don't have such practice, so basically in terms of employment relations, consent should be like the most reliable option. And according to the practice, if you deal with Roskomnadzor, being a data protection authority in Russia, they also very keen to see consents as a ground for data processing because it's like the most understandable option for them. Also, there is a pretty conservative approach regarding whether consent could be granted for several purposes of data processing. Roskomnadzor, officials of Roskomnadzor during several events have noted that there should be only one purpose of data processing consent. However, practically a lot of it is not really business convenient, so that's why purposes can be combined and there could be different options how to ensure that data subject has granted consent for each of them. For instance, you can put signature or tick a box in front of each purpose, or you can add in the end of the consent that the data subject acknowledges that he or she has been able to amend the text of the consent. So there are a couple of options that could be used in order to avoid this pretty formalistic and actually not really reasonable approach of the data protection authority. Basically, there are 2 types of consent. Right now, we have the third one regarding dissemination of personal data, but we will speak about it later. So the first one is so-called simple consent, which can be granted in any form. The main issue here that data controller should be always able to prove that consent has been indeed granted. So if you use, for instance, click consent on the website or some electronic form of consent, if there are any inspection or dispute regarding whether consent has been granted, you should be able to prove that exactly this person has granted his or her consent. And in limited number of cases, the data protection law requires so-called written consent. You can see some of them on the screen. I would say the most important is like processing of special categories. If you process any information about health data, you should ensure that written consent has been obtained. There are a couple of exemptions. For instance, if you process personal health data regarding an employee in order to understand whether he or she fits the position and job function he or she performs, then you can do this without consent. And regarding measurement of temperature in terms of COVID, the Data Protection Authority has also clarified that no specific consent should be granted for that. Another case when the written consent is required is cross-border transfer to so-called non-adequate or unsafe countries. We'll speak about this later as well. And transfer of employees' data to any third party, irrespective whether it's like cross-border transfer within the borders of the Russian Federation. So written consent, basically the most conservative approach is to collect it in paper form with as a wet signed signature. But the law also allows electronic document signed by the digital signature as a written consent. However, there is like a controversial approach in the law, because if we read the law from the very legal perspective, we should say that the written consent should be signed only by so-called digital enhanced digital signature. In practice, usually data subjects in Russia don't have such e-signature, and therefore it is not like practically viable option. However, in this year, in response to the request to Roskomnadzor, the officials have clarified that even so-called simple e-signature can be used for that. Simple e-signature means that if you can identify a particular person in relation with you, for instance, if the person logins with its nickname and password on your website, you can assume that this person signs any documents on the website on behalf of him or her. And therefore, even this option could be used right now in practice in order to ensure that written consents have been granted. So definitely this is something that could help in the digital world when you don't have any physical connection with your client, with your customer. So this is definitely a good development of the recent practice. Further, we'll speak about performance agreement, and I will pass the word to Irina.
Thank you. Yes, another popular ground for processing of data is performance of agreement, but it's important to remember about key requirements to use to be able to use this ground. So first, data subject should be a party or a beneficiary under the agreement. So if you have an agreement with your counterparty who is a legal entity, for example, you need to make sure that actually the data subject whose data you are processing is at least a beneficiary, because he's not a party to this to this agreement, but at least a beneficiary. And this may be tricky from time to time because not always actually the data subjects are beneficiaries. So this ground is great, especially for online resources such as online shops, for example, because our DPA already said that they understand that terms of use are basically an agreement for the purposes of this provision, so it's great, but for others it can be kind of tricky. Again, performance of agreement can be used as a ground of processing, but what should be taken into account is purpose limitation. So if you have a particular purpose, for example, purchase of a table, for example, as under this agreement, it doesn't mean that you can use this data for targeting and for profiling and any other fancy business that your marketing may be wishing to do. So there is a purpose limitation rule which applies to this as well. So if you have a limited contract, your processing is also limited. No excessive processing. So if you actually need for this agreement to ensure the purchasing of a table only limited amount of data such as name, phone number, maybe address for delivery, then you do not require any further data such as preferences or anything else. And this always faces issues with additional technical identifiers which are collected somehow automatically through the website, and the operators or controllers, they say that, but this is covered by the agreement, but then the purpose of the agreement does not allow this excessive processing. So this should be taken into account as well. And also what is great is that performance of an agreement as a ground of processing allows cross-border transfer to unsafe, inadequate countries. We will talk about this later, but this is what should be remembered, not only written consent, but also performance of an agreement. And again, for online business, it's great because, as I mentioned, Roskomnadzor, they considered the online terms of use as an agreement. So this really helps because many online shops, they have their servers where they send data not in Russia. So this is really helpful. But again, when I refer to this clarification from Roskomnadzor, you need to understand that it was more or less official clarification things. So it was published on the website. So we can refer to this, but this is not written on the stone, unfortunately, so far. But this is what market lives with, and basis is processing on, so you can actually use this. Next one, our favorite, is a legitimate interest ground. As you know, in GDPR in the EU, there is also legitimate interest ground, and it's actually frequently used in Europe. While here in Russia, we also have this kind of processing ground, but unfortunately, it's not that favorable for us to use, and it's quite risky, I would say. So what does the law say? Processing of data, we can process data when it's necessary for performance of rights and legitimate interests of an operator or third parties, or for public interests, if processing does not breach rights and freedoms of a data subject. It's quite similar to what is written in GDPR, and under GDPR you need to have this balancing test, whether interests of operator do not overrule interests and rights of a data subject. So you need to actually balance that, and after you balance that, you can process this data on the basis of legitimate interest. And this document in Europe, this document should be in place in the organization. In Russia, we do not have such a requirement, which can be considered good or bad. Good because we do not need another document, bad because we actually cannot use this ground, unfortunately, because Roskomnadzor, they say that it's very easy, to use this ground without actually having a ground. So they warn all the operators not to actually rely too much on this ground, because this will require substantial evidence, and what kind of evidence, nobody knows. So this ground is really risky. But in some cases, it is still used, for example, for anti-corruption checks, for know your client procedures, for something like that, which is actually prescribed by the law, but probably you can do something additional according to your policies, not excessive, again. But this, at least, our DPA says that this kind of processing can be covered by the legitimate interest. And this position, they transfer of all events so far. The position of our DPA can change very quickly, but so far, this is what we have. So to sum up, with legitimate interest, you need to be particularly careful. You can use it in some cases, like we mentioned on the slide, but for others, especially for marketing purposes, etc., this is not what can be used. Yes, and then we go to the dissemination of personal data, which is, as I mentioned, a hot topic and recent news.
Yes, so basically in March this year, new amendments to the data protection law have came into force, and I would say they're pretty controversial and disputable, both from the standpoint of legal technique and as well as practical applicability. But we believe that it should be considered from two angles. The first one is when you, as a company, as a data controller, disseminate personal data, and the second one is when you want to use publicly available personal data. So let's consider this step by step. So the first one, the first thing that we should qualify is what is dissemination. Dissemination is making personal data publicly available, so that it can be accessed by any person without any restrictions. So this, like, evidently, this means publication of personal data on the website or on some other platform which can be accessed by any person. So, for instance, if you have some global intranet page where you share contact details of your colleagues from all over the world, but it is accessible only by colleagues from different parts of the globe of your company, this is not dissemination. So these new rules do not concern such situations. Transfer of personal data from controller to controller, controller to processor are also out of scope from the new rules, so there should be no concern. So we are speaking only about making personal data publicly available. So the main requirement is that right now data controllers should collect separate and specific consent for the dissemination of personal data. Roskomnadzor has clarified in official regulation what should be included in this consent, and let's consider like the most crucial points. First of all, you should indicate information resources where personal data will be published. According to the clarifications, this should be platforms, websites owned by the data controller. However, we think that it's like quite reasonable to have the approach of assessing whether you have control over dissemination of personal data or not. For instance, we internally, not sometimes, pretty regularly, publish information about our employees on different resources. It is our website, our internal CMS website for different alerts, newsletters, and other guides, in LinkedIn and Facebook. And in our consents, we have mentioned those platforms where we control whether we want to share personal data or not. So for instance, we included LinkedIn and Facebook, although we don't own Facebook or LinkedIn, but it's our marketing colleagues who decide that, okay, we want to publish this newsletter with, for instance, mine and Irina's surname. So we control this personal data regardless of the fact that it is owned by Facebook. So we allowed our employees to decide whether they want personal data to be disseminated on our website and on other platforms, YouTube, for instance, where data can be accessed by any person. The second issue is that the consent should provide for the possibility of the data subject to put some restrictions or conditions of data processing for all people, for all data controllers who will access personal data. And you cannot limit this possibility to some certain restrictions. You should provide like an open question, open field where data subject can impose any restrictions and conditions that could pop up on the mind. So basically how this could work. For instance, me as a data subject, maybe I can allow dissemination of my personal data, but I don't want it to be collected by any other person so that everybody could have access to it, but they shouldn't download it, use it in their internal systems, etc. And for the data controller who want to publish this personal data, I can say like, you should warn all other data controllers that they should only access my personal data. No downloading, no collection, no other operations with personal data. I can also put some purpose limitation, for instance, that it cannot be used for any profiling or marketing. I can also restrict processing of data in not depersonalized manner. So there are actually a lot of issues that could be raised during this process of collection such open consents. But if you receive consent and there are some very unreasonable restrictions and conditions, you can always discuss this with data subject and explain to him or her that certain restrictions could limit your ability to perform certain operations with these data subjects. For instance, if you cannot perform agreement without certain publications personal data, you can refer to this necessity and say that if you put these restrictions, we will not be able to do certain things to you. So it's also about negotiations with the data subject. Also important thing to know that the requirements provide for the necessity of data subject to choose all data that he or she allows to be disseminated. So that right now you cannot put the list of all personal data you would like to publish. You need to put a tick box in front of like name, surname, contact details, email, etc. And data subject should consent to each of these. So like basically tick box is the perfect option how to ensure that all that data subject wants to choose has been chosen. And finally, the form of such consent. Gratefully, there is no requirements for written form, so it could be received in any form that you like, which will really help in case you don't have any physical access to data subjects. So if there are employees, it's pretty easy to receive written consents usually, but right now during pandemic, it's not that easy sometimes. So that's how you can manage this. We have allowed internally, we have allowed to use both paper forms and online forms, which can be provided to HR and DPO, and then all these consents are stored internally in order to prove that dissemination is lawful. And right now, let's switch to the second issue regarding use of publicly available data. Right now, if you see some personal data, let's say on Facebook or LinkedIn, you can access to this personal data and read it and review it, but any other operation with personal data should be justified by any other legal ground that we have discussed previously. So right now, there is no such legal ground as processing of publicly available data. So for instance, like let's consider recruitment process as like one of pretty understandable scenario. A lot of recruiters use LinkedIn pages or Facebook pages in order to collect certain information about potential candidates. And right now, if you already have like names, surnames, CV of potential employee, and you would like to use certain information from LinkedIn, which is not in this CV, we don't recommend doing this. So what you can do is actually just add in your internal database a link to the LinkedIn or Facebook page, so that you can access this personal data pretty quickly in terms of business operations. At the same time, you don't collect this personal data to your internal databases, which should be justified by most probably consent in this case. But of course, if there is, maybe it's the case when legitimate interest can be used sometimes. So if you, for instance, need to check whether the counterparty signing the agreement, whether the agreement is signed by the authorized person, you can check trade register, Russian trade register, in order to be sure that this is really a managing director of this company and that he or she authorized to sign the agreement. So right now, you should be every time very cautious when using publicly available data. You should check restrictions and conditions. You should always bear in mind that there should be justification for your further processing of such personal data. The next slide is consent for advertising.
Yeah, with this dissemination of data, there are still many questions. There is no good practice, unfortunately, yet. I mean, good substantiated practice or anything. So we are using mostly what is discussed with the regulator and what they publish in their notifications. But we'll see. Stay tuned. So we move on to this very interesting topic of consent for advertising and marketing. So prior consent to receive advertising is required by both the data protection law and advertising law. These are more or less similar provisions in both of these laws. So this consent must relate to specific advertiser or distributor of advertising. But the practice now actually kind of ignores the second part, the distributor of advertising, because basically what our mobile operators do, they base the spread of advertising on the consent that they received for them. So they say, we received the consent for spreading the advertising for us and any third parties. So we can allow banks and other organizations to actually send advertising to consumers through us. And the Federal Anti-Monopoly Service, who is in charge of advertising regulation, says no. There should be a particular expectation that should be met. So the expectation of the consumer should know and what he can expect, what kind of information he actually agreed to. If he gave a consent to a mobile operator, then it basically means that advertising of this mobile operator can be received, but not of the bank or any other organization, because it's too excessive. But still there is this collision, because the law says that it could be consent for a distributor of advertising, but in practice it's not like that. So maybe this will be changed, this provision. Next, consent must be explicit and expressed. It, like Vladislav said about general consent for data protection, also it cannot be hidden in long texts. And I will give you an example of the official position of the regulator in this regard. Consent must be voluntary. The service cannot depend on consent. So you cannot say, until you give us a consent, we will not provide you the service. No. So this should be voluntarily and separate from anything else. Of course, your marketing will not like this. They say nobody will come, nobody will sign up for our advertising because we cannot. People don't like advertising. They say normally in this situation, well, make them like your advertising, because there are creative ways to actually make the advertising information very attractive. And I know that I think most of you already know some examples, because I have several in mind where I actually like reading some advertising emails from some particular companies, because they're very creative, and I do not want to actually delete them or unsubscribe. So this is what should be done. The official position I was referring to was issued by Central Bank of Russia and Federal Anti-Monopoly Service quite recently in September. Yeah, in September, about marketing consents in advertising. Oh, sorry, in agreements. Finally, we have this clarification, because it was actually much needed. And please do not be confused that this only refers to banks. Officially, yes, but since this is an official position of Federal Anti-Monopoly Service, this should be considered for any kind of activities for any organization, because this is the approach that will be used. So they say that in practice there are cases where marketing consents, and we all know that, are included into the text of an agreement, and the application or the document and consumer or applicants cannot refuse providing such marketing consent. We all know the situations when you come to the bank and you want to get, for example, a loan, and you sign all the documents, and if you try to change something, they say, no, it's not possible. It will take weeks before you actually get the loan. It's impossible. So they say, the Central Bank and the Federal Anti-Monopoly Service say that the absence of an opportunity of a consumer to refuse such a consent, not to give such a consent for receiving advertising, is actually an unfair practice. So let's believe that in the coming years we will not see any more these agreements where this consent is included in some hidden provision somewhere in the very small text, or even that it will be included in the normal text, but you can actually remove it. Let's see how it works. I personally, when I see some kind of applications of this kind of agreement, and I see this provision, because I'm a specialist in this field, I do, I just put any sign that I do not want this. This is one way, if you can do this. Of course, it's not always a bank. In bank, it's a different situation. But with others, it's possible. If they rely on this document when you send you an advertising, then they will have real problems because they need to show the document, and it's, you know, everything is marked there that I do not want this. So for you as advertisers, on the other side as business, it's important to have a separate field for consent for advertising, where the consumer can actually express their will or not will to receive such an advertising. This is an example how it can be done in online. For example, here I have read and accepted the privacy policy, and here we have subscribed to our newsletter to receive information about all the latest news trends, offers, and promotions for your home. For example, it's a home online shop that sells home stuff. So you see there are two different tick boxes, and what is important, they are not pre-ticked. The pre-ticked check boxes are out of date. We should forget about them because we don't have this case law so far, as far as I know. But the Federal Anti-Monopoly Service actually fights directly with the big companies who provide for pre-ticked check boxes. I know from my clients who say that we were called to come to Federal Anti-Monopoly Service, and they were talking to us, this kind of warning that if you do not remove this kind of pre-ticked check boxes, then we'll come after. So this is actually happening right now. So first, two separate checkboxes, and there should not be pre-ticked. What we have now in our legislation is a part that was included together with the dissemination of personal data provisions. And it says the silence or inaction of the personal data subject under no circumstances can be considered consent to processing of personal data permitted for dissemination. What is really weird is that it's included only in this provision that relates only to publication and dissemination of personal data. Although, you know, this provision should be somewhere at the beginning of the personal data protection law, and it should apply to any processing, basically. And we expect, and we see it already in practice, that it actually already applies to any kind of processing, even if it's not dissemination, if it's just processing, internal processing, but this requirement was ignored, then they can apply this provision as well. Although from the legal technique point of view, it's kind of confusing, but still. We in Russia sometimes proceed not from only the word, the text of the law, but also from its general attitude and understanding. So this is the general attitude that should be used for personal data and for advertising purposes as well. So we move on to the last part of our presentation before we continue with the questions and answers, and this is of course the dessert of our presentation, the localization requirements and cross-border.
Yeah, so localization requirements is something that is like discussed during the last already 6 years. So yeah, 6 years has passed since the moment localization rules have been adopted. So basically, as I think all of you already know, so what localization rule requires that data controller should initially store, record, and store personal data of Russian citizens in the Russian database. Only after that, personal data can be transferred abroad. So, in the sense of the localization rules, it's important to understand what is considered as collection. So, collection, according to the clarifications of the Ministry of Digital Development, collection is a deliberate process of receiving personal data from the data subject or third parties. So by this interpretation, the authority has excluded accidental receipt of personal data from the localization requirements. So for instance, if you use some email servicing tool which is hosted abroad and you just accidentally receive some personal data of a person, you haven't asked for and you don't intend to process further, you can simply delete this and no localization requirements will be applicable to these cases. Besides that, there is also an exception regarding exchange of contact details between legal entities. So for instance, if we as a law firm communicate with any of your firms, and of course, like, it's not the legal entities who communicate, it's their employees. And this exchange of personal data, for instance, through e-signatures in emails, this falls out of the localization rules as well. So you shouldn't initially store this personal data in the Russian database. There are certain more exceptions explicitly established by the law, but all of them are not applicable for business, so we will not concentrate on this right now. What is like? Sorry, I forgot to click. Yeah. What is like most crucial development is the increase of fines, which happened in 2020. And basically, right now, the fine for the first violation of the localization rules can be up to 67,000 euro. And for the repeated one is the one that is committed within 1 year from the previous one. The fine could be up to 130,000 euro. So in practice right now, we don't see a lot of cases when high fines apply. Of course, we heard about like major cases regarding Google, WhatsApp, and Facebook, but definitely we shouldn't really consider this as a practice making, because it's rather like politically driven, and this is definitely the intent of the authority to show that we will prosecute with high fines for the refusal to comply with the localization rules. However, we don't really know a lot of cases when high fines would apply to like business already present in Russia, who has Russian subsidiary or representative office, and who actually does business in Russia. There are a couple of court cases where companies have challenged the prescription of the authority in charge regarding necessity to cure violations of localization rules. And a couple of them were pretty successful when Roskomnadzor was not clear enough on what should be cured, how it should be cured. So right now, practically, we don't consider the risk of the high fines as very high, but because it exists from the legal perspective. And still, we have the possibility to block a website or the application if it is used to collect personal data of Russian citizens, and personal data collected through this website or application is not localized. As you most probably know, localization rules do not prevent further cross-border transfers subject to compliance with requirements of such transfer, which we will discuss right now. So the law requires cross-border transfer. Before cross-border transfer, the data controller should check whether the country where data is going to be transferred to provides for adequate measures of protecting data subjects' rights. In Russia, this means that you should just check the parties to the Strasbourg Convention 108, which means almost all European countries, as well as the list adopted by Roskomnadzor, where certain additional countries are included. For instance, Japan is included in this list of Roskomnadzor since 2019, and it is considered as a safe or adequate country in terms of cross-border transfer. So there are no specific rules if you want to transfer personal data from Russia to Japan. You should just justify it by any legal ground available under the law. It should be also noted that 1 month ago, I don't remember, in September or October, the list has been slightly changed. A couple of countries like Argentina or Morocco has been eliminated from the list, and a couple new countries have been added. So you should monitor this list from time to time in order to have like an up-to-date list. It is updated usually once in 3 or 4 years, so it's not very frequent practice of Roskomnadzor. All other countries which are not included in these two lists are deemed as unsafe, The most, I would say, frequent cases when data is transferred is the United States, China, and India, where some data outsourcing happen. In order to transfer personal data to an unsafe country, you have a limited number of grounds which can justify such transfer. As we have discussed previously, it is a written consent, which applies in majority of cases. It is also a performance of the contract, as Irina has mentioned. But again, it is very important to understand that if you want to transfer personal data abroad for performance of the contract, you should be really able to justify that this cross-border transfer is indeed necessary to perform the contract. If it is just like excessive cross-border transfer, this will be illegal, and it's better to collect written consents in order to be on a safe side. Finally, the question regarding intra-group data transfer, because in some countries there are specific and less harsh rules for intra-group transfers. Unfortunately, in Russia, we don't have such rules. So even headquarters or any company of the same group of companies are treated as a third party, and depending whether it is in Russia or outside of Russia, you should apply the basic rules for transferring personal data. It should be also mentioned that Russian law, comparing to the GDPR, doesn't require data transfer agreements between when we were speaking about transfer from data control to data controller. So this is not that is strictly required under the law. However, in order to show the compliance and transparency to the regulator in terms of your process and operations, we recommend to conclude such data transfer agreements, especially on intra-group level, if there is excessive and active sharing of personal data among companies of the same group. So actually that's it.
Final
checklist, and then we'll move to questions.
Yes, we did not want you to leave without a practical checklist from us, so we prepared this one. Probably it will be easy to use. So first, we need to remember that there is a wide approach for qualification as personal data, as we talked about this. Legal ground for processing is very important. The most popular one is still, unfortunately, consent. Next, the dissemination of personal data requires separate consent. Use of publicly available data is still a gray zone because it requires some additional legal ground, but it's not clarified yet how exactly it should be processed. Then marketing consent should be separate and explicit. Collection and processing of Russian citizens' data requires, as we know, databases in Russia, and cross-border transfer is allowed, but special conditions for unsafe countries apply. So this is the checklist. Of course, it's very high level, and each business has its own peculiarities, but we hope that this is still useful for you, and we will be very glad to answer your questions after I remind you about our YouTube page, where we have our IPTNT webinars and recordings. There are some of them in English, some of them are in Russian, but please subscribe. Ekaterina, who is our marketing manager, will be very happy if you subscribe, and you're welcome to also participate in the discussion there if you have any questions. We also have LinkedIn, of course. We have Facebook, where you can follow all our further events. We are very glad to welcome you there as well. So thank you for your attention, and we will be glad to answer your questions.
First, as a Chenko, I'm management's so at the beginning, you were talking about some specific personal data, which could be the MAC address of your laptop, the email, the phone. In this case, does the use of the corporate laptop or corporate phone make an employee's personal data?
Mm-hmm.
And should we receive some special consent for employees if you want to proceed with that or possibly transfer?
Mm-hmm. That's a great question. Thank you. Well, first of all, we need to understand how you actually are going to process this data, because basically you own this laptop and you already have this information from the beginning, right? It's not some new information. But if you want to track somehow your employee bearing this laptop and see where he goes and what he uses, then it can be a processing of this.
I'll just give some background.
Yeah.
We use this information in case of cybersecurity. So for that investigation, we can use this MAC address and address and so on. So in this case, should we include this information into our employees' consent?
You can use, like, generally what we recommend to do when there is something about tracking of employees and what they're doing on the corporate laptop is to include in the consent the wording that that data subject consents to processing of information about his or her actions on corporate devices, and this will include like IP addresses and several other, like, for instance, emails, etc. Basically, why this requirement like initially came when there are some usually labor disputes with ex-employees, and there is a necessity to check email box, I mean corporate email box, and for instance disclose it to the court. There is a question whether such check of the email box could be considered lawful from the personal data standpoint. Generally, you can justify this by like necessity to proceed in the court proceeding, but if you have such wording in the consent, it will like
make it easier.
Yeah, make it easier.
Remove the speakerphone in case someone else wants to ask.
Do we have something from online? No?
Not yet.
Oh, yeah, okay. Yeah.
Some question.
Sorry, could you please speak up?
Speak up, yeah.
We have, because of
online speakers.
All right.
Careful, so much
So here.
No, just speak
Just
louder.
Louder. Okay, louder. Question regarding help desk.
Oh, yeah.
At the moment, all legal entities are obliged to inform to governmental bodies the quantity of the person who actually in office, who is out of office, and who had a colleague or who was vaccinated. Should we include the consent into the consent for employees, these grounds of personal data processing, the health data, because actually it is required by law. So we don't want to process this personal data. And should we include and inform personal as well that we process special category of personal data?
That's an interesting question. Well, I would say that indeed it's required by the law, which means that in case of some dispute, we can justify it somehow, but be careful with the exact wording of the law, because, for example, in Moscow, it said that you need to ensure, for example, some percentage of vaccination of your employees, but it doesn't say, please give us names and dates of this vaccination. It does not require that. So how you do this ensuring the percentage, it's tricky, you know, so in case of a dispute, they will follow the exact wording. But of course, to be on the safe side, I think the majority of companies have included already the wording into the consents about the health data, because it's pandemic and you never know what kind of processing will be required for this data. So of course, it can be limited to reasonable processing, and your consent should be also limited to actual processing that is required. It should not be excessive as usual. But yeah, I would say that including this into consent would be reasonable. About informing Roskomnadzor, this is a good point. I mean, everyone is now processing health data because they have to.
From the legal standpoint, you should,
Yes.
like the approach of Roskomnadzor right now, that like almost every legal entity should provide a notification, and the notification should include all information about your processing activities. So definitely this processing of health data in order to ensure compliance with the law is some like separate processing operation. And I would say that you can inform Roskomnadzor regarding this.
Well, you should.
Yeah.
Under the law.
Yeah,
At the moment, we do not indicate in our personal data protection policy that we process the special categories of persons. Therefore, we need to change and to inform.
Yeah, under the law it's like this. I mean, about all the changes in the scope of data, you have to inform. Of course, in practice, it's quite difficult to track all the companies who have not informed, but in case of any attention to your company, this will be the first thing they will do. And they normally do this. They send a request and say that please update your application, your information in the registry. If you don't do this, there is a minor responsibility for this, like 5,000 rubles. But still, you get under their attention, which is not pleasant, as we all know. If you just inform them about this change, this will bring less attention than in case of this kind of communication.
And also, you can check if you are already in the register of data controllers in Russia. You can check your current record, and maybe there is like a general warning that you can process personal data of employees for the purposes of compliance with the law. And in the list of data that you process about employees, you have health data. So in this case, you can just refer, if there are any questions from Roskomnadzor, you can just refer that, look, it is reflected in the identification.
Yeah, because normally organizations process such data, with regard to sick leave of employees or something like this. So probably it's already there. But,
We should check.
Yeah, I mean, maybe you have checked already, but yeah, if you haven't, maybe there's some room, for safety. Yeah.
We have a question from our auditory.
Online?
Yes, from online. So should cookie data be treated as personal data?
I was waiting for this. So, in Russia, we do not have anything particular in this regard in the law. As you may notice, many companies on their websites already have a cookie banner and it already became a market standard, even for Russian companies as well. There is a position that is somehow orally transferred by the data protection authority that they do consider cookie as personal data. And what is even worse, that they consider, for example, Google Analytics as being a non-localized database for personal data, meaning cookie. So they advise to use some national alternatives that are out there for this kind of processing. So if we take into account this wide approach and quite strict attitude of the data protection authority, we would say that rather yes than no. And taking into account this practice that all these technical identifiers were considered actually personal data, we can see that probably cookie data is also should be there. And also when there is kind of a gray zone, our regulator sometimes looks at the European practice, and in Europe, as we know, cookie data is considered as personal data. So rather yes than no.
Yeah. And also maybe to elaborate further on the cookie files cookie files from US service providers, which are frequently used by Russian companies, because this involves cross-border transfer of personal data to the US entity, which is non-adequate country from the standpoint of cross-border. And from the pure legal standpoint, you should receive written consent for this. And definitely it's not something that is business viable to collect written consents from persons who have just access to your website. And right now, one of the options that hasn't been directly confirmed by the data protection authority so far is that when you like you can process cookie not on the basis of consent, but on the basis of legal ground for performance agreements. So you can treat access to your web page as acceptance of the terms of use of your website by each user, and in order to like perform this service, access to the website, you need to use cookies. And on the basis of this performance of contract ground, you transfer personal data to the United States.
Which is, of course, tricky because in order to actually read the terms of use, you need to access the website, so you can. It's quite tricky.
Yeah, it's just how you. Sometimes there is a business operation that should be performed that is important for the business, and formalistic requirement could be an impediment in order to do this. And if you cannot ensure 100% safe option, there are ways how to try and at least justify that you have tried to make it in a lawful way. So for instance, as with a legitimate interest, if you understand that without legitimate interest, there are no other options how to process personal data, you can use the same approaches under the GDPR to do a balance test, and if there are any inspection, you will show a balance test and say why you believe that legitimate interest is admissible option in this case. So there are ways how to know that.
And sometimes you see just a warning on the website that we are using cookies.
Yeah.
So if you consider some kind of consent or not, if you proceed.
At one event, I heard from our DPA that you can use this kind of disclaimer. I mean, it's not perfect, but it's something, they said. So probably that's the reason why the Russian companies also began, to use this kind of disclaimers on the websites, because it's at least something. And Roskomnadzor said that it's better than nothing. So.
And actually, Roskomnadzor, as far as I remember, Roskomnadzor, they themselves, they use approach of the cookies to be a part of the performance of the contract. So if you go to the Roskomnadzor, as far as I remember, it's definitely some of the authorities, but as far as I remember, it's Roskomnadzor, and they admit that use of the cookies by them is part of the performance of the contract.
Well, good luck to them.
Most probably they will not find themselves in the easy position.
And also about the cookies, it's interesting. I've heard a story from my friends recently. They were organizing an event, and they were building a website for this event of Tilda. Tilda is like a constructor for the website. It's very easy to use without coding. Nice. And they somehow figured out that Tilda collects a lot of cookies, and you cannot control this, and you cannot change this, because this is as is service that you take on, you do not take. So they were thinking, and these friends of mine, they're privacy specialists, and they were like, what do? We do not want this cookie. We will not even have access to this cookie. And what they did, they wrote in their privacy policy that for cookie, Tilda is an operator or controller of data, because we do not use them, we did not set any purpose, we did not set any way of collection, and we do not have access to this. Therefore, we are exempting this data from our operator activity. So this is also an option, and you need to be really careful with technical solutions that you use. Probably some of them actually use more than you know, and then you need to have this legal ground and legal justification for everything. Not to scare you, but this is the reality.
Can I ask one question?
Sure.
About cross-border data transfer? Suppose we have the personal data in Russia, and we got the consent from the employee, but our other employees can connect to the system and check the personal data. Do we have to get further consensus from employees?
Yeah,
especially if that is the unsafe countries, India, China, or US.
Actually, this is the question whether access to personal data from the foreign country should be treated as cross-border transfer. And if you look at the like what is written in the law, it is written like transfer, and in the brackets, dissemination, provision, access to. So all these three operations are deemed as transfer of personal data. And therefore, even access to Russian database from abroad should be considered as personal data transfer as well. Yeah, so in order to be on a safe side, definitely it's better to sign the consent for access to the data of respective employees.
We have another question from online. So, how to comply with localization if the employer asks to take some educational courses on the international web platform, and there is a registration form? Who collects the personal data in such case?
Well, educational platform already collects, of course, collects this data. If you, as an employer, transfer this data to the educational organization yourself, then we presume that you already localized the employee's data and it's in your local database, and then it's just a code for the transfer, which is subject to conditions that Vladislav mentioned. But most likely it will be educational organization itself who will collect this database, and then there is a question whether the Russian law and localization requirement is actually applicable to the foreign educational organization. And this is a big topic, of course, but generally speaking, if they are not targeting Russian people, if they are not placing Russian advertisement and allowing, to pay for the education in rubles or something like this on their website, then most likely they will not be considered as falling under the Russian law. But if they are actively targeting and trying to attract more people and do everything that I mentioned, then most likely they will have to localize the database. And this is actually a very good question about the application of the law to foreign companies. We don't have 100% clear answer to that, but this targeting criteria is something that should be used.
Yeah, and also in this case, so like if we consider that employer would like to encourage some education, like additional education of employees, I would say that it also depends how this educational process is structured. So for instance, if like CMS will say us, okay, you can go and take the courses on some international web platform and we will reimburse your costs for this. So in this case, it will be relations between the international web platform and me as a user of this platform. And employer doesn't have any processing activity in this process, so they just pay for my education. It's our employment relations, and there is no interception into the data processing activity between me and web platform. But if, for instance, employer makes some direct agreement with the web platform that you will educate our employees, then there is a direct connection between employer and web platform. And web platform definitely will be data processor in this case. And there should be an agreement between employer and data processor that we will provide you with data of our employees who will participate in the course, and you should protect this personal data, process it only for the purposes of educating people, etc. So it's all about perception how employee is involved in the educational process. Yeah, I think that's what the question was about.
Yeah.
But currently we are using the LinkedIn educational services across the globe, and we are able to, we Russian members are also can able to connect to the services through our internal portal. But the actual services are provided by LinkedIn. In that case, who will have to get the consent from employees?
Who's collecting the data? You, right? It's you collecting the data.
Of course, we,
And
the company, are getting the information who will connect to that LinkedIn services. But at the same time, LinkedIn also has to use the information, the personal data. Otherwise, they cannot identify who's using.
Yeah.
Yeah.
I would say that you need to, most probably when you like subscribe to this option in LinkedIn, you have accepted some terms and conditions, and most probably LinkedIn has them, but definitely they are not in line with the Russian law. Yeah. It's like LinkedIn is not accessible in Russian. Definitely, we shouldn't wait that LinkedIn will publish some restrictions on dissemination of personal data. Most probably they will not care about this. So what you should do in this case is just to ensure that so you provide the opportunity to your employees to make some additional, to receive some additional indication on LinkedIn, and you provide access to this like special, let's say, special room, special service on the platform. So in this case, like, most of the data has been already localized by you. It's data about employees. And most probably everything LinkedIn will receive is just like names and position. Yes, so nothing special. So I would say
It's for the transfer, yeah.
It's for the transfer. So you should just like collect consent, I would say, from your employees in order to allow them to use LinkedIn. But at the same time, they do this themselves.
Yeah, if they are already registered on LinkedIn and all this combined, then it's easier. But if they are not using LinkedIn and they are not registered, then so LinkedIn will receive this data from you, not from the user directly. So this means, yes, that you need to be in charge of these consents for cross-border transfer.
I forward task all of them myself.
Sure.
My name is Kawada from NEC. Our company is producing some biometrics solutions like extracurrition and print and iris, etc. Of course, globally we have many customers, but for example, we should get some consent with a customer or some operator. They not use such kind of violation with some law or something like that. Because sometimes I'm not sure that the customer or some person go to the court, and the companies or operators are violations. Also, it is belong to the supply some solutions. Is it possible? Such kind of responsibilities.
So you provide only a technical
Yes.
instrument for this kind of face recognition.
Yes.
Do you receive the data,
Stores.
store the data? Is it
No.
stored in your database? No. Do you somehow access it, use it to identify a person, particular person?
Technically, of course, yes. Of course, we are doing.
But if it's not stored on your database, in your
No.
database on your servers, then probably you do not know who is this particular person because you do not have access to this data. Because biometric data is something that is used to actually identify this person using fingerprint or face recognition, image or something. So unless you have such a possibility to access data and identify a person, you are not.
So responsibility on the operator.
Operator.
Expiration
Yes.
or something.
Yes. So the operator who sets the purposes, the scope of data, the use of the way to use of this data, etc. This is the person who actually needs to have a consent. You, as just an instrument, technical instrument.
And so the one more question is, for example, now many companies are now using Facebook and Instagram for the businesses. For example, today we are coming here and make some photo shooting and upload to. Even it is internal kind of some seminars. So we hold such a seminar last year.
Yeah.
With some of our employees. Upload without some consent. Of course, it is a kind of a dangerous, right?
Yeah, previously we would say that you need to care only the right for a person's image, and if it's like a public event and you kind of took a photo and said we will publish on Facebook and everyone heard it, then there would be less risk, But now with this dissemination of data, if you just publish an image, and do not write the name and surname of the person, then most likely it's not a dissemination of personal data, because image of the person itself does not count as personal data unless it's biometrically used afterwards for identification of a person. So image itself is more or less fine, provided that you consider the right of a person for image. If you mention, so on our seminar there were this and this and this and this and this, yeah, or something, tagging people on Facebook or in LinkedIn, then we would need your written consent. That's how we will not publish it.
Even now we are situation, but the camera only takes us, not all of you. So.
Our consents are in place, but not to care.
If we take the photo and upload from here, that will be considered as the personal data, right?
If I take your photo,
your name is on
Yeah,
the
yeah,
photo.
sure, yeah. It will be personal data. But again,
we have sent it anyway by ourselves. We'll send it.
yeah, but like as we have discussed, like if you use it in your personal account, that's fine for sure. But if you use it like on your corporate account, I would say that you actually you will need to justify this additionally, because you take disseminated personal data, which is like lawfully, let's say in the internet, like this slide will be in the internet, so you can access it. But in order to use it on your website, you should justify this by some other legal ground. Yeah. So if you could create something with legitimate interest by using our image and names, maybe you can do this, but most probably consent is like the most preferable option.
In our case, we will not object.
oh, we will be happy, please.
It's just in theory.
Feel free. There is a recording going on. We said that we will not object this.
Yeah, but this is not an indemnity from the fines.
Unfortunately, yes, because there is a consent. Yeah. Are there any other questions?
Yeah, I have a question. Actually, we have also online courses for our staff, and these courses are only accessible by our group staff, like not only in Moscow office, but some offices all over the world. And the company which provides the courses is an American company, USA company. But it's like especially for our company, no people from outside of company cannot access these courses. We provide our email addresses for registration to our headquarters, but we, like most office, does not register our staff directly. We do not know how our headquarters registers. Maybe they just buy some number of accounts, and after that they do not inform email addresses to the provider. I'm not sure. So what could you give any advice to us? Maybe we should check with the headquarters how they communicate with that provider, or are we like relatively safe or not?
Yeah. I would say that like the first thing that you need to do in this case is like you provide this educational, not service, educational opportunity for your employees, and you involve American company as a data processor for this. So given that it is involved for your headquarters, I would say that you need to execute a data processing agreement with your headquarters, where you will state that we will provide you personal data of our employees for the purposes of arranging education, and you can involve sub-processor for this purpose, which will be this US company.
And this will be your liability or responsibility as our contract. And I think you process this data with headquarters not only for this purpose. Probably there are many other purposes while headquarters have this.
But in this case, it's only like email address. In other cases, we transfer like much data.
I think everything is already there, right? So you first collect here, you localize them, of course, and then you make them available for your global teams, right? For headquarters. So they already have access to all the data of your employees here.
Not
all data, but
because first we took written consent from all our staff, and then we transferred the data. Actually, we have two headquarters, and legally our headquarters is in Tokyo.
Yeah.
But recently our office was became subject to London regional headquarters.
Yeah.
Legally, it's not our headquarters, but we transfer data to them. It's also one more question.
But I mean, good news is that it doesn't matter. For the Russian law, all of them are third parties that are separate legal entities,
Yeah.
and with each of them you can enter into this data transfer agreement and state all the purposes and scope of data and ways of use of this data that is happening.
Yeah, as to data transfer agreement, I think London office mentioned that we should conclude, but as to Tokyo office, I don't think we have any.
Yeah, it's normal because in London they are still kind of close to GDPR.
They have
So it's pretty much the same, and data transfer agreement is required. In Japan, as far as we know, it's not the requirement per se. It's like with us, it's good to have. It's actually recommended to have, because when you have the audit or inspection by the data protection authority, you will show all the flows of your data. You will have to do this, right? And if they see the flow of your data to your headquarters in Japan, for example, and it's not anyhow, covered, because you need to ensure confidentiality, you need to ensure technical measures, organizational measures, and everything. Of course, you can just agree in email, but it's not enough. So it's better to have this kind of data transfer.
Yeah, but as to our personal data transfer to Tokyo headquarters, it happens like not with all staff. They do not have our staff's personal data. So only in cases when somebody goes to Tokyo on business trip, maybe wants to have some training program.
Yeah.
In that case, we transfer such data. That's why we do you think we still need this data transfer agreement?
Well, it's better to have it, of course, especially if it happens from time to time, not to think every time what to do, just to have this ecosystem of everything that you do.
And which advice would you give us about our e-learning provider? But because I don't know who exactly communicates with the provider, either it's our London office or it's our American office. Probably it's our American office, but we never communicate directly with our American office, only communicate with our London office. It's so complicated. What would you advise us?
Yeah, so what is very useful for you, first of all, as a person who is in charge, to have a kind of a map. Like you just draw it. It's just as simple as it is. That you have your organization, you have your headquarters in Tokyo, you have your headquarters in the UK, you have other companies, you have your service providers, your or not your, like e-learning or something else. And then you draw the arrows how you communicate with whom, and it becomes really clear that you communicate with this office, and this office communicates with this office, and this office communicates with e-learning system, and then you see the chain. So you do not communicate with them, so there is no agreement. There should not be any agreement in place. So this is your connection, and you do not communicate with e-learning systems. So how can you enter in the agreement, because you are not in direct relations with them? So your only direct relation is your headquarters, and then, as Vladislav mentioned, they hire others.
So we need the agreement only with London, right?
Or with Tokyo, or with someone who
But
you actually.
With that, like American office, which we do not communicate.
I would say that it would be.
It depends, like your data controls, like you in charge for controlling data, you do the transfer. So it should really reflect like how it works in practice. I mean, if you just provide details of your employees to your London office for further e-learning process, what you should do is just to put on paper what is really happening, that you provide this data to London. London then can provide this data to the US office or directly to e-learning platform, and this e-learning platform is better communicated in the data processing agreement, so that you provide emails of your employees for e-learning purposes, and your London office is entitled to further appoint a data sub-processor, which is actually e-learning platform. So it's all about to reflect what is really happening in practice on paper.
Thank you very much.
Dear colleagues, we reached the time limit for online portion, so we can continue here, of course.
Or here.
But we must say goodbye to all our listeners from online. So thank you very much for connecting us, and we will be glad to see you, or at least to have you connected to us on our next events. So
yes,
thank
you very much.
We are finishing the online translation. Thank you.
Thank you.
Thank you.
Colleagues, we can continue with questions.
We can make it more informal and
Yeah.
we could go to zone.